Welcome. First, we will frame what a sudden policy freeze in asylum decisions is, and why it hits so hard after years of waiting. Then, we will walk through the review window, likely outcomes, and a tactical response plan. Finally, we will close with practical takeaways, a brief quiz, and resources to keep you prepared. Let's begin. Next, here is our roadmap. We will start with the reality of a decision freeze, then interpret what a 90-day review signals, followed by the two likely outcomes: extended delays or procedural changes. After that, we will develop a strategic waiting plan, build a documentation toolkit, and learn how to monitor legal challenges. We will also prep for potential re-interviews, test your understanding with a short quiz, and end with key takeaways and next steps. Before we dive in, a brief but crucial disclaimer. This presentation provides general information and does not constitute legal advice. Policies change frequently and vary by jurisdiction. Please consult a licensed immigration attorney for guidance specific to your case. Watching this video does not form an attorney-client relationship. Moving on, let's acknowledge the reality. A decision freeze is a system-wide pause in adjudication for a category of cases. After years of interviews and compliance, finding out that decisions are suspended is devastating. It reflects institutional review and policy shifts, taking temporary precedence over finalizations, creating legal and emotional limbo for applicants. Now, what exactly is a decision freeze? It is a directive from leadership that pauses adjudication for a defined category of cases. It often follows internal audits, new memos, or director-level policy shifts. Even applicants who have completed every required step find their files halted. This is controversial because it imposes indeterminate delays on people who may already be in vulnerable positions. Let's visualize the flow. The applicant completes the interview and biometrics. The case moves into the decision queue. Then, a policy memo announces a freeze, halting decisions. At this point, two paths may emerge. In the first branch, the applicant waits while monitoring updates and litigation. In the second branch, a procedural change leads to a supplemental interview request, requiring preparation and legal representation. After the supplemental interview, the case returns to the decision queue and eventually receives a decision once the freeze lifts. Next, let's decode the review period. A stated 60 to 90-day window generally signals intense scrutiny, sometimes of both past and future standards. Two outcomes are common. First, prolonged delay, where a temporary pause extends significantly. Second, procedural changes that introduce new evidentiary standards, leading to potential supplemental interviews even years after the original one. To put the review in time perspective, imagine this timeline. Day 0, the freeze is announced. Over the first month, internal audits and stakeholder consultations occur. By days 31 to 60, draft procedures are prepared. Days 61 to 90 see new guidance announced or the review extended. Beyond day 90, extensions are possible, especially if litigation or policy complexities arise. The key point is that a stated 90-day window may extend beyond initial estimates. Now let's translate uncertainty into action. First, contact experienced counsel immediately. Second, do not attend any re-interview without representation. Third, assemble a clean, indexed evidence binder. Fourth, draft updated declarations and timelines to reflect any changes since your initial filing. Fifth, track official updates and credible litigation news to anticipate shifts. Sixth, create a rapid response kit so you can answer sudden document requests quickly. Seventh, maintain personal stability, including housing, work authorization renewals if applicable, and mental health support. Here is a practical organization table. Group documents by category. Identity and entry includes passports, identification, entry records, and travel documents. Core claim evidence covers affidavits, country condition reports, and any medical or psychological evaluations. Procedural documents include receipts, notices, interview letters, biometrics notices, and any Freedom of Information Act responses. Maintain a timeline of personal updates, incidents, and address changes. Finally, keep attorney materials like representation forms, legal analyses, and cover letters readily accessible. Track the status of each category as ready, missing, or updating. Let's compare two approaches. Passive waiting means relying on hope alone, not monitoring updates, keeping documents unorganized, and risking missed deadlines. Stress remains high and control low. Strategic waiting involves actively monitoring official channels and credible litigation updates, maintaining an organized and indexed evidence set, and preparing templates for rapid responses. This method often reduces stress by increasing readiness and control. Before we quiz you, here is a Markdown-style checklist for re-interview readiness. If contacted, notify your attorney immediately and request representation at the interview. Ask for the scope of the re-evaluation, including issues, standards, and documents. Confirm date, time, interpreter requirements, and location in writing. Review your original declaration and update your personal timeline. Prepare concise, labeled exhibits that correspond to any new standards. Practice truthful, consistent testimony with your counsel. Bring original documents and organized copies in a clearly indexed binder. Quiz time. If you are asked to return for a re-interview during a decision freeze, what is the best first step? Option A. Attend immediately to avoid more delays. Option B. Decline and wait until the freeze is lifted. Option C. Go only if you can record the meeting on your phone. Option D. Contact an experienced immigration attorney and do not attend without representation. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is to contact an experienced immigration attorney and do not attend without representation. Representation helps you understand the scope of new standards, prepares targeted evidence, and reduces risk under heightened scrutiny. Second question. A public memo announces a 90-day review to create new procedures. What should you expect? Option A. Exactly 90 days, and then immediate decisions resume. Option B. Likely prolonged delays and possible new evidentiary standards, including supplemental interviews. Option C. No change because the memo is only symbolic. Option D. Automatic approvals after 90 days. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that you should expect likely prolonged delays and possible new evidentiary standards, including potential supplemental interviews. Review windows often extend, and new frameworks can trigger re-interviews well after the initial interview. To round out your plan, consider this mind map. The center is strategic waiting. From there, legal counsel covers retainer arrangements, scope letters, and interview preparation. Always. Documentation includes an index, organized exhibits, and updated timelines. Monitoring reflects agency alerts, litigation tracking, and reputable news sources. Well-being emphasizes mental health, supportive community, and stable routines. A rapid response kit consists of evidence templates, cover letters, and reliable document delivery options. Here are the key takeaways. A freeze is a top-down pause. Stay informed rather than immobilized. Expect both delays and possible procedural changes, and prepare for re-interviews. Do not proceed alone. Contact counsel before any return interview. Use the waiting period to organize, index, and update your evidence. Finally, track legal challenges and official channels to catch the earliest signals of resumption. As we conclude, focus on what you can control. Schedule a consultation with a qualified attorney. Build your indexed evidence binder and update your timeline. Subscribe to official alerts and schedule regular check-ins every 2 to 4 weeks. Prepare a rapid response kit for sudden requests. Finally, maintain routines, support networks, and self-care to remain grounded throughout the wait. Thank you for joining. If this video helped, please like, share, and subscribe so others can find it and so you receive timely updates. We would love to hear your experiences and questions in the comments. Your insights help this community grow stronger.